When you run a business, entering into contracts, negotiating contracts, or in any way thinking about entering into a contract is non-negotiable. It's the life force of your business. It's part of your day-to-day operations. But I find that most businesses make the mistake of either entering into poorly written contracts or entering into contracts that are not legally enforceable. But how can you avoid those mistakes? How can you pinpoint what a strong, legally enforceable contract looks like? Here are the things you need to look out for because every strong, legally enforceable contract has them. And if you find that there's a contract you're about to enter into that doesn't have any one of these, completely about turn. Do not enter into that contract. Make sure that one or all of these things are in your contract. The very first one is proper party identification. Who are the parties that are about to enter into the contract together? Where do they live? Where is their address? What kind of person are they? Are they a natural person or are they an artificial person? If they are an artificial person, what are the important information you need to know about them? For instance, their registration number. What kind of company are they? Proper party identification is very, very important. And if your contract does not properly identify who the parties are, what their role in the contract is, who they are, what kind of classification they are, whether natural or artificial person, you need to make sure that that is included in your contract. Otherwise, walk out. Simple. Second thing is that the contract must have a recital. Now, a recital is basically a summary or a brief description of that contract, what the contract is meant to do or what is meant to act as. It shows, or in that recital, it's meant to contain the essential elements of every contract, which is what? Offer. It must show that XYZ offered da 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 to person A, and person A is willing to and accepts the offer of person. It must show that offer. It must show an acceptance. It must show mutual consent because contracts entered into under duress do not hold up under the law. And in fact, they are punishable if anything. So you must have a recital that shows the offer, shows the acceptance, shows consideration if possible, shows mutual consent, and briefly describes that contract and the purpose of that contract. Third thing you need to look out for that every strong legally enforceable contract has is a service scope or a description of services. Now, it outlines what the obligations of each parties are. What is each party going to be doing and what should the other party expect so that you avoid things like scope creep in your ongoing contract enforcement, right? So what are it must be detailed. Your services or your service scope in your contract must be very, very detailed so that you know what you should expect, when you should expect it, from whom you should expect it, and how you should expect it. So that you manage your expectations and don't go being disappointed when something you expected but was not contained in the contract does not happen. The fourth thing you need to look out for is the payment terms. Payment terms, if you miss any other thing in a contract, please do not miss payment terms because more contracts have fallen or broken off because of non-payment or because of non-compliance with the payment terms. So it's better for you to take adequate care to make sure that your payment terms covers checks all the boxes that it is supposed to check and that there are no ambiguities in that clause. The fifth clause that every strong legally enforceable contract has is a term and termination clause. How long will that contract be for? Contracts typically are not meant to run in perpetuity. There is supposed to be a start date and a finish date. How long will that contract be for? And what is the exit plan for that contract? When can parties decide, okay, I no longer want to, be in this relationship with you, in this contract with you, I want to leave. What is the plan to that? You can't say, oh, we love ourselves, we respect ourselves, or we do anything to ourselves. So therefore, I would no. Write it down. How long does a contract last for? When can each party leave? And what are the exit strategies that you guys have in place? The sixth thing is governing law and dispute resolution. I see someone make this mistake once when they took an online template and they did not customize it for themselves. They didn't review it, they didn't give it to a lawyer, nothing. They just took the online template because it marginally applies to them. And they immediately signed it, entered the contract, and boom, they were already in practice. When it came time to enforcement, when there became issues arose and it came time for enforcement, and they gave it to a lawyer to look at. They found out that the contract that they got off the internet was applicable in the Netherlands, and it was governed by laws in the Netherlands, and they were in Nigeria. So tell me how you're in Nigeria, the subject of the contract is happening in Nigeria, both parties are Nigerian, and there's laws in the Netherlands that apply. Hmm. This one is for all of you people that get that DIY the law. You try to go online, ask ChatGPT to spit out an agree. This one is for all of you. So, if in any contract, in a legally enforceable contract, you need to make sure that the governing laws are actually accurate and accurately apply to the subject of the contract and to the domicile of the parties to the contract. And for dispute resolution as well, do you want litigation to apply? Do you want arbitration to apply? Mediation, negotiation, conciliation? What kind of dispute resolution mechanism do you want to apply in that particular case? It is in this clause that you write it. And if your agreement does not have a dispute resolution clause, then please make sure that it is included in it. It's not that we are saying bad things or conflicts will arise. It's not that we are saying that no, but it's just a means or a way to protect yourself should they happen. The next item or the next clause that legally enforceable contracts have is a confidentiality clause. Because let's face it, each and every one of us that have businesses have confidential information that we have in our businesses, information that gives us an edge in the market, and we consider it confidential. So it's also important that our contract reflect that information and give respect to the information so that it doesn't turn up and become public knowledge. Another key clause is IP assignments, ownership, licensing, basically any clause that has to do with intellectual property. In this day and age, it's very, very important to have such a clause, especially if you are in the digital space in one way or the other, or if your product in one way or the other deals with the digital space. It's very important that you have some kind of IP ownership, assignment, or licensing clause in your agreements. Another clause that you need to look out for are something called boilerplate clauses. Now, these are clauses that are repeated in almost every contract you sign. They are clauses that are constant, they are repeated. You cannot have an agreement and not have at least one of these boilerplate clauses. And what are those clauses? They are the force majeures, which is like, they basically deal with when the contract becomes frustrated out of by acts of things other than the parties within the parties control rather. So force majeure, you have severability, you have waiver, you have the execution clause, very, very, very important. You have the witness clause, you have notice and all that. So these are boilerplate clauses, and every legally enforceable and strong contract has or must have a boilerplate clause, or at least two of them, the execution clause being the most important of all of them, and then force majeure also being very important. Now that you understand the key clauses that legally enforceable contracts have, what are the mistakes that certain people have made in the past, and how can you avoid making those mistakes? The very first one is using ambiguous language in when you're drafting your contracts. We are past that age where we try to use Queen's English, KJV version English in drafting contracts. We're way past that, right? So if you're drafting a contract, whether you're doing it for yourself or someone else is doing it for you, or you are a lawyer watching this video, please make sure that you simplify the language used in your contracts. Make them as simple as humanly possible so that they're easier to understand and so that it doesn't get lost, or the intent of the parties don't get lost in translation. The second mistake that happens and how you can avoid it is you leave out key clauses to save time and or resources. Again, back to my DIY lawyers that are not actual lawyers. They're just people that go on the internet, pick things, and they try to DIY the law. Don't try to save time or save resources by doing things like that, because most 9 times out of 10, you end up getting yourself into more trouble and you end up paying more for that trouble to be corrected. So don't leave out important details in your contract simply because you're trying to save time or you're trying to save resources. You end up spending more and it's not never worth it. Mistake number 3, failing to update your contract as your business relationship evolves. Now, say for instance, you have a business relationship with someone, they start off as an independent contractor, for instance, and now they have evolved to becoming or to being a full-fledged employee in your company, and they're still under the ID or the IC, independent contractors agreement. That cannot work because your business relationship has evolved. Therefore, your contract must also evolve to match the current pace of your relationship. So don't make that mistake, okay? Another mistake is again copying random contracts off the internet and trying to use it without customization. Don't do that. It's never a good idea. It never works out well. The last, and thankfully people don't do this as often as before, at least I don't see it, is relying solely on verbal contracts or verbal agreements or, you know, things that might not hold up in court, relying solely on them. I say, no, no, don't do that. Get it into writing, even if it's your internal communication between staff in your company. Get it into writing. It saves you from having your intent being subject to another man's or the reasonable man's interpretation. Now that you understand the key clauses that every legally binding contract has and you understand the mistakes to avoid, why is contract so important? The very first reason why is because it's the life force of all your business engagements and relationships. So if it's not done properly, you find that you're just running on vibes, and that's not very sustainable. So that's one of the reasons why you need to take it very, very importantly. The second reason is that it helps you manage your expectations because it outlines what rights you have, what obligations you have, what are the responsibilities of the other party, what should you expect, so that you are it removes the the disappointment factor, at least it reduces it significantly, so that you know what to expect, when to expect it, how, and so on and so forth. It clarifies your intent and it makes your intent enforceable rather than having a verbal agreement that is then open to interpretation and becomes hearsay after a while. With a legally enforceable, properly worded contract, you don't have to worry about any of that because your intent is perfectly captured and it is perfectly enforceable. So, guys, that's it for today. Actually, it's a very short video where I just wanted to tell you because I've seen where founders make this mistake of having one of these clauses missing in their contracts, and they've gotten into trouble for it in later times. So to make you not make that mistake, I've outlined this key clauses that every legally binding contract must have, and I hope you took note of them. And that's it for today, guys. If you love this video, then please subscribe because next week I'm actually going to tell you the fundamental essential contracts that every startup needs to have. Because if you're a startup operating anywhere in the world, there are certain contracts that you must have because they are crucial to your operation. And next week, I'm going to outline all of these contracts for you. So make sure you subscribe so that you can get notified of those. Bye.